So our class today is what is capacity and how is it determined? Our presenters today are from CANNR, California Advocates for Nursing Home Reform, as well as Community Council. And I'll let our presenters briefly introduce themselves before we get into our topic today. And with that, I'll go ahead and stop sharing my screen and I will let you take over, Andrew. Thank you again for being here.
Hello, my name is Andrew Figueroa. I'm a staff attorney with Community Council, and we'll be giving myself and my co-host presenting capacity and advanced planning.
Hi, good morning, everyone. My name's Jenny Nguyen, and I'm a staff attorney with Community Council.
Hi, everyone. My name is Arabelle Molinas. I'm a staff attorney at CANNR. So I wanted to talk a little bit more about what CANNR does in case you don't know about us. We're a statewide advocacy organization specifically serving long-term care consumers, older adults, and people with disabilities. We do not only direct advocacy through our toll-free number that anyone can call for free and get the advice, as well as community education, legislation, and litigation. And then this is our services. If you have any questions with these areas, this is what we provide guidance on. We also have really great fact sheets on our website, canhr.org. Next slide.
So I work at Community Council, where our organization stands with our community to help protect rights, preserve independence, and promote dignity. Through accessible, free legal services, we help individuals and families navigate life's most critical moments with clarity and strength. Our organization specifically provides services in estate planning, probate note clearing, limited conservatorships, preserving homeownership, disability rights, and education rights.
So this is what we will discuss today. So we're going to talk about just capacity and what that is. Conservatorship, what are the alternatives to conservatorships, including power of attorney. There's also case studies, and then discuss some, in brief, advanced planning tools to coordinate with the capacity documents. Next slide. Okay, so the basis for this is actually, and it's in the law, is a person's right to autonomy and the right to make their own decision. It's foundational tenets in our society. It is, again, in our laws. And so there is an existing perception of capacity. And even when someone has some cognitive impairment and diminished capacity, the law actually instructs that at least restrictive alternative must be sought before taking it away. Next slide. So here are the common questions that we're going to address, and this is also the questions that many of the people in attendance asked. What are capacity letters? Is it capacity medical or legal? How do you get them? What are they used for? And what about their people if they're unable to make their own decisions? What happens? And then what about power of attorney and healthcare directive? So this is all going to be discussed in our presentation. So again, capacity is a legal determination. The way with medical, it is evidence of either capacity or incapacity, and that's where you get capacity letters from doctors. There's a rebuttable presumption of capacity. So there's presumed capacity, but there has to be evidence that does evidence to the contrary to be able to overcome to determine that somebody does not have capacity. There are different levels of capacity, so it's very task specific, and I'm going to discuss that later. And then all persons are capable of contracting, except for minors, persons of unsound mind, and persons deprived of civil rights. So this is provided under the Cal Civ Code 1556. Next slide. Again, I can't this about presumption of legal capacity because it's really important. I think especially when there is an existing perception within like with older adults because of their age. So even if someone exhibits, forgetfulness or even mild dementia, there's still a presumption of legal capacity. And so here's what is an example of task specific capacity. Um, and that's with the creating Advanced Health Care Directive. It's provided under probate code. So they're all laws that specify what type of capacity is required. So contractual capacity, for instance, is a higher level of capacity. So that's when you're creating a durable power of attorney for finances, when you appoint another person to be able to make decisions on your behalf in the event of capacity. So it's higher because you're dealing with people's assets, their finances. Whereas if it's a testamentary capacity, which is a lower bar, it's creating a will, and that might not be as involved. And then comparing it to creating a trust, which is a lot more involved. And so I've provided a list of what is required to be able to meet those different capacity standards. Next slide. So as I said, the court is the final arbiter of capacity, and it's through the conservatorship process, which Andrew is going to discuss in a couple slides. And what the court looks at, and it's even in the judicial counsel forms, is that there has to be a least restrictive alternative that's been explored even before granting a conservatorship. And this is specifically in the law and in the forms, and it'll be constantly the topic will come up in a conservatorship proceeding. Next slide. So again, it's a conservatorship process that determines or that can take away a person's right to make their own decision, like legal capacity. With capacity letters are letters by medical doctors, and it's an assessment that doctors make, and it's usually a very thorough assessment of the person which with their cognitive function, and it would either demonstrate an evidence of capacity or incapacity that, if it's in a court process, would be submitted to the court. Next slide.
So the next question people are going to ask are, okay, I've received letters of incapacity. What do I do with them? If you have a power of attorney we use the legal term springing, which just means that it takes effect when a certain condition is met. And most traditionally with powers of attorney, that's when the principal or the creator has lost capacity. So you would use these letters of incapacity to show, look, the condition has been met. I now have an effective power of attorney. I am the active agent. Now, there are a few different ones. One of the most classic one is a letter of incapacity from the primary care doctor. Another is 2 letters of incapacity from 2 separate doctors. Either way, the letters of incapacity are needed to show that the condition has been met. Now, what the agent, the person with the power of attorney would do is they would take the letters and the document of the power of attorney and show them together to show, look, this is a document that states the condition. These are the documents that show the condition is met. And that location they would take it to varies depending on where they need to exercise it, whether that be at the bank, Social Security, or sorry, not Social Security, the bank, medical offices, wherever they need to go to show they have authority. Now, I'm going to turn to what Arabelle mentioned earlier on conservatorship. The hope with the power of attorney and the other estate planning documents is that you don't enter into this process. But if you do have to enter into this process, you have to be aware there are 3 types of conservatorships. There's a limited conservatorship, a general conservatorship, and an LPS conservatorship. While the names can be a bit misleading, a limited conservatorship is specifically for adults who have developmental disability, such as autism, cerebral palsy, epilepsy, intellectual disability, so on and so forth. Limited conservatorship does not mean that your powers are limited. It's just the classification. A general conservatorship is specifically for adults who have lost capacity after the age of 18. And that can be due to almost any reason, such as dementia, Alzheimer's, they had a stroke, Parkinson's, some other severe brain injury. And again, general is just a classification. It's not saying you have more powers or less powers. Under both conservatorship processes, there are kind of two types. You have a conservatorship of the person, which are personal decisions, medical, where they're going to live, things along those lines. Then you have conservatorship of the estate. That's more financial decisions, how pay their rent, manage their bank account, manage benefits, and so on and so forth. Now, I'm not going to delve too far into LPS conservatorships because they're a special type of conservatorship for people with psychological illnesses like schizophrenia and can only be initiated by the public guardian or by a psychologist. But let's say a conservatorship process has begun. What does that look like? The first thing is the petitioner, the person seeking to get the conservatorship of somebody, is going to file a petition. That's going to be filed with the court. It's usually done by a family member or some other interested party, such like a close friend or something like that, to initiate the process. Next, there's going to be an investigation. So the court is going to appoint an investigator to investigate the situation and determine if a conservatorship is necessary. Because as Arabelle mentioned earlier, they're looking for the least restrictive alternative. They want to make sure this is the only option. At the same time as the investigation or immediately afterwards, you want to give proper notice. You want to notify the person you're trying to get a conservatorship of to say like, hey, we're trying to get a conservatorship of you. You also need to notify their family. You have to notify any other interested parties, such as if they already have an attorney, you want to notify their attorney. After those processes are set forward, you enter the hearing stage. So that's when the court holds a hearing where the evidence is going to be presented, where arguments are made for and against the necessity of conservatorship. Then the court will pass an order, either granting or not granting it. If the court does grant it, the order also specifically says who is going to be the conservator. Like, is it a family member? Is it a private fiduciary? Is it the person who initially said a conservatorship was needed? And in that process, they're going to limit the rights of the conservatee. Because at the end of the day, a conservatorship is taking somebody's rights to make decisions and giving them to somebody else. So that can include the right to vote, control salary, the right to marry, to receive personal mail, be represented by a lawyer, the ability to ask a judge to change their conservator, the right to ask a judge to end the conservatorship, the ability to control personal spending, to make or change a will or any other estate planning document, and the ability to control medical decisions, all of which are broad and wide-reaching powers. But as we talked about least restrictive alternatives to conservatorships, I'll turn it back to, we'll discuss a few more. First is the representative payee. This is a very useful situation to use, especially when somebody's receiving federal benefits, because the law requires that some Social Security benefits, and this also applies to veteran benefits, they require that legally incompetent adults and adults with disability have a representative payee. It's just a very fancy way of saying a special type of power of attorney specifically for this program. And the process is more or less straightforward. The forms are all online. You can see the process, how to be selected, and how to request to be one. And it could be a family member, a friend, it can even be your conservator or some other organization. The veteran, like I mentioned earlier, the VA also has their own separate program for representative payee that's separate from Social Security. Just note that if you make a power of attorney, Social Security and veterans, because they have this representative payee process, tend not to honor a state-powered power of attorney.
So another process that offers a least restrictive alternative is what's called a supported decision-making agreement. So it's an agreement that you can use in addition to the power of attorney. And it's essentially for people to have trusted members, supporters in their lives, friends, family members that could help them choose. Like it's kind of like their support team. So in this agreement, it can be formalized. So it would be signed by the person creating it and their supporters. And it could be for many different parts of, their lives. So next slide. So an example would be personal care. So even hygiene, taking medication, clothing choices, living and working arrangement, even get transportation, choosing where to live, staying safe. And a lot of times too with finances, dealing with finances, money, paying rent bills, budgeting, money. And so we provided a link to a sample of the support decision making. It's been in existence for many, many years in the people in the community of disabled community. And it's been recently adopted into law. So it's been in existence, it's honored. And if I think it's helpful to have it because with the power of attorney, especially the uniform statutory power of attorney, it's only a couple pages. This will provide additional information to be able to support someone, especially someone with who has like cognitive impairment, and then if there is, for instance, dementia, and it'll decline. And so this will help them through that process. Next slide.
Okay, so now we're going to get into powers of attorney. So when we say power of attorney, there are generally two types of power of attorney, and that confuses a lot of people. Um, One covers your healthcare, which is your Advanced Health Care Directive, and the other covers your finances, which is your durable power of attorney. These are two separate documents and they do two different things, but ultimately both are things that you should have. And so we're just going to walk through each one so you can see the differences clearly. So what is a power of attorney? A power of attorney, or a POA, is a legal document where you can choose someone you trust to make decisions for you in the event you become unable to do so for yourself. You can only create a POA while you still have capacity. If someone is already deep into dementia or has had a severe brain injury, it's unfortunately too late to create one. And at that point, the only option is to go to court for conservatorship. A POA can be either immediate or springing. It can essentially be effective as soon as you sign it, or it can spring into effect, meaning a springing POA only kicks in when a specific condition is met. And usually that condition is when a doctor certifies that you have lost capacity. You'll often see the word durable on these documents. Durable basically means the document stays in effect even after the person loses capacity. A POA ends when the person who created it passes away. It's only for use during a person's lifetime. So an Advanced Health Care Directive governs medical and healthcare decisions. It essentially spells out your wishes for things such as end-of-life care, organ donation, and things like funeral arrangements. It also lets you name a specific person called your agent who can speak with your doctors and make medical decisions on your behalf when you can't. Under federal privacy law, HIPAA, hospitals and doctors can't share your medical information with your family without authorization. So an Advanced Health Care Directive allows your agent to have access to your medical records. The second type is a durable power of attorney for finances, or a DPOA for short. This one has nothing to do with your healthcare or your healthcare wishes. The DPOA is about who is able to manage your finances, like your money and your property. It lets you name an agent to handle things like paying your rent, your mortgage, managing your bank accounts, paying bills, dealing with insurance, and managing property. Both documents have a principal and an agent, or an attorney, in fact. The principal is the person who creates the document. For example, if you are making a POA for yourself, you are the principal. If you are helping your parent set one up, your parent is the principal. The principal is the one deciding who their agent is and what powers that person should have. An agent can also be called an attorney in fact. They are not actually considered your attorney, but this is just another term for an agent. Your agent can be anyone you trust, a family member, a close friend, a trusted neighbor. They don't have to be an attorney. For a principal and agent, they both need capacity. The principal needs capacity at the time that they sign the document. They have to understand what it is that they are signing and what powers they're giving away. And the agent has to be a competent adult. You can't name a minor, someone under the age of 18 as your agent. Even if a principal is in the early stages of dementia, they may still potentially have the capacity to sign a POA. It really depends on whether they understand that they're signing, or what they're signing, and that they intend to sign it.
So when you select your agents for both the healthcare directive and the durable power of attorney, your agents have special obligations called their authority as well as their fiduciary duties. So in a healthcare directive, when you pick an agent, your agent under the law, probate code section 4684, they shall make healthcare decisions based on principles individual healthcare instructions, and if not known, in accordance with the agent's determination of the principal's best interest, which is a fancy and lengthy way of saying that they're meant to follow what your wishes are to the best of their ability, or if your wishes are not vocalized or not known for some reason, it's something novel that you never considered, the agent's supposed to act in what they believe you would have done or would act in your best interest. Similarly, under the power of attorney, your attorney in fact or your agent has the duty to act in accordance with the powers you've given them under the power of attorney. They also have the duty to act solely in your best interest and avoid conflicts of interest. So they can't do something that would benefit them but hurt you at the same time. They also have to manage funds carefully. So what that means is they can't do anything that would prevent them from keeping track of where the money was spent, how they used it. They have to try to avoid, in all instances, mixing your money with their money or your money with someone else's money. And they have to keep good records of what they were doing.
For an advanced healthcare directive and a power of attorney to be legally valid or official in California, it must be properly executed. So there are two ways to do this. One option is to have two witnesses sign after the principal signs. And one important note to remember is that the agent can't be one of the witnesses. Option two is to have the document notarized. Notarization is required when a POA involves real property. There's a special rule for the healthcare directive. If the person creating the document, the principal, is a patient in a skilled nursing facility at the time that they're signing the healthcare directive, a patient advocate or ombudsman must also sign a statement under penalty of perjury, meaning they're legally signing and legally confirming that the principal is signing voluntarily and without pressure to do so. The Advanced Health Care Directive is the one that covers your healthcare decisions. You might hear this document called by different names. Some people call it a POA for healthcare, others call it a living will. They're all basically referring to the same thing. It's a document that lets you state your healthcare wishes and name someone to carry them out. The document can give your agent the authority to make very serious decisions, including end-of-life decisions. Part 2 of the standard Advanced Healthcare Directive form is where you would spell out your wishes about life-sustaining treatment. Those are things like whether you want to be kept on a ventilator, whether you want tube feeding, and under what circumstances you would want treatment to be stopped. Without an advanced healthcare directive, your family might be left guessing or arguing with each other about what you would have wanted. When you create an advanced healthcare directive, you want to choose your agent carefully. This person this is the person that you may have to tell that may have to tell a doctor to stop treatment. So you want to pick someone who can handle that emotional weight and who will respect your wishes, even if they personally disagree. So you want to talk to your family and your friends about your wishes. The more people who understand what it is that you want, the smoother things will go if and when that time comes. Lastly, you also want to give a copy to your doctor so that it's in your medical file. So what you're seeing here is the form. This is what the California statutory form looks like. This is for the Advanced Health Care Directive. And statutory form just means that it's a standard form created by the state adapted from the probate code. So since it's widely available, you don't necessarily have to hire a lawyer to help you fill this out, although speaking with one beforehand is always recommended. The form is, again, freely available online. It's written to be understandable and legally sufficient when properly signed. And you can also find this form at your local law library. On the slide, I think you forwarded. You're on the other slide. Yeah. So on the slide, you could see to the right under part 2 is a section where you would spell out your wishes around life-sustaining treatment. So I would encourage you to just look up the form. Reading it really forces you to think about the questions that you may have never considered. Okay, next slide. So just like the Advanced Health Care Directive, California also has a statutory form for the DPOA for finances. Pictured is the statutory form, and again, it's freely accessible. It doesn't require a lawyer to complete, though for more complex financial situations, consulting an attorney is always a good idea. And the form is broad and it covers the most common financial powers. Next slide. The durable power of attorney for finances gives your agent or your attorney, in fact, the legal authority to handle financial and legal affairs. Like all POAs, it expires at the principal's death. Once the person passes away, the agent's authority under this document ends. If the DPOA is set up as a springing POA, the agent may need a doctor's note confirming that the principal lacks capacity before they can use it. On the statutory form, there's a special instructions section where the principal can specify limitations on what their agent is allowed to do. One thing that you want to consider is including a restriction on the agent's ability to sign arbitration agreements. For example, say your agent signs a contract with a contractor to do work on your home and that contract has an arbitration clause in it. If something goes wrong, instead of being able to take that contractor to court, you may be limited to a private arbitration process.
Oh, I wanted to, and Jenny, also add with the arbitration, it's really common in nursing home admissions agreement and residential agreement. So if there was any neglect or abuse in the nursing home and it resulted in, death or serious bodily injury, a lot of times a nursing home would want to get people into arbitration instead of through a court where it's in front of the jury. So it's really important to another reason why it's important to have specified to withhold the power to enter into arbitration agreements.
Thank you for adding that. Here's where the DPOA actually comes into play day to day. When the principal is unable to manage their own affairs, the agent under a DPOA can step in to access bank accounts, pay rent or mortgage, cover utility bills, manage investments, or handle any other financial matters that the principal would have handled themselves. Without this document, families may potentially find themselves locked out of accounts, unable to pay for care, or may be forced into may be forced to go to court for a conservatorship.
Now, under power of attorneys, there's two concepts. Springing, which we've mentioned a number of times, it's basically you make your healthcare directive and power of attorney effective upon determination that the principal lacks capacity. Now, again, that's the most classic example and the most common use case. It's not the only situation. You can always condition it on in the year 2035, in X amount of years. You can always set that to be the condition, but normally the recommendation is use capacity as the determinator. When you use capacity as a determinator, the doctor's note determining incapacity of the principal is to carry financial transactions for the principal. That's important simply because the bank will ask for that note when they review the power of attorney. If you give them a power of attorney without the letters of incapacity, the banks will be like, that's great. Come back when you have the letters of incapacity, then we can talk. Another thing to take note is that under the power of attorney and the healthcare directive, these documents are revocable, which means that at any point in time during your life while you have capacity, you can take them back. You can make changes. You can say, you know what, I named my child as my agent, but you know what, they're being very irresponsible with money. Let me change it to my best friend instead, who I know is more responsible. You can make those changes as long as you have the capacity to do so. The only caveat is specifically with the power of attorney, durable power of attorney, you have to send a notice of the revocation to your former agent when you create a new power of attorney or when you revoke the power of attorney, especially when you're changing the agent.
So we're going to go over some of the misconceptions of POAs and just because there's so many out there, and here are the most common ones. So um, an agent under the healthcare directive, this for the Advanced Health Care Directive, can override decisions of the principal. This happens sometimes, especially with fraught family dynamics. And the law actually says no, the principal, the person that created the Advanced Healthcare Directive, has the final say. If the principal objects to the healthcare decision of the agent, the matter shall be governed by the law that would apply if there were no power of attorney for healthcare, which means that if there was no power of attorney, assuming that the principal has capacity, then they make the final decision. Also, agent must make healthcare decisions as I was discussed before in accordance to the principal's healthcare instructions and other wishes, and then otherwise their best interest. So with the best interest standard, it's considering their personal values to the extent that's known to the agent. Next slide. An agent can make decisions after the principal's death. Yes, it can, specifically for the donation of organs and body parts, authorizing autopsy, directing dispositions of remains, even releasing medical records post-death. With regard, there are specific boxes that can be checked off in the statutory form, so they can specifically authorize or withhold um, those items. Agent's healthcare directive has expired because it was created 20 years ago. There's no expiration date for a power of attorney. Cantor gets a lot of calls like this, especially when hospitals don't honor them. And so it might be worth calling either Cantor or community council about this because it's just probably additional advocacy to educate the person, the staff member who says that it's expired and point them to the relevant law. And the other one is as principal, I can appoint my minor child, and as discussed before, you cannot because they don't have capacity to contract until they are over the age of 18 or over. Next slide. We get this question a lot. What if there is no power of attorney, but the patient has capacity and there needs to be medical decisions and they need to appoint someone? They could do it through a health oral designation, so stating who they want to have as a healthcare surrogate. And so, as long as the healthcare appointed healthcare surrogate is an adult with capacity, they can inform the healthcare provider or the staff at the healthcare facility, and they have to be recorded in the patient's medical record. Next slide. But what if the patient lacks capacity and they don't have a power of attorney? Well, absent a conservatorship, if it's like a healthcare one time or a healthcare decision that needs to be made, there is a way, and it's through a doctor or a facility, nursing home facility administration. They can select the person, the healthcare surrogate, that demonstrates special care and concern for the patient and who's familiar with the patient's values and beliefs. It doesn't need to be a relative, but what they do have is, they consider relatives of spouses, adult children, parents, if they have parents or siblings. They do consider the familiar relationships. And then if there was no capacity, no power of attorney, and this was discussed in the previous slide, so this is the hierarchy of who they consider a healthcare surrogate. And so again, they prioritize spouse or domestic partners, adult child, parent, sibling, adult grandchild, and then adult relative or close personal friend. So what if they need an emergency intervention and there no POA, no conservatorship, no capacity? There is a interdisciplinary team that will review the resident's condition and the proposed medical procedure and make decisions on the circumstances. And the Office of Patient Representative from the Institute of Aging, they are also involved. And so if there's a person that does not have any family members, the Office of Personal Representative can step in and be involved in the interdisciplinary team. Next slide. So another thing to keep an eye out is that power of attorneys, particularly durable power of attorney for finances, can be exploited, and it has been exploited. And so it's really a lot of financial institutions are really vigilant about that. And so if you suspect that there was fraud or scams, and not just POA for any fraud or scams, but because we're talking about POAs, it's relevant there. Considering financial there are publication out there from the Consumer Financial Protection Bureau and the Federal Trade Commission. And we provided links on the slide.
Now we're going to talk about some case studies to kind of apply what you've learned in a more practical sense. So case study number 1. Jane, a 75-year-old with Alzheimer's dementia, is in the hospital for a urinary tract infection. She has an Advanced Health Care Directive prepared by an attorney 15 years ago. The directive appoints her husband, deceased, as primary agent and her first child, her son, as secondary agent. Jane needs to be admitted to a skilled nursing facility for rehab. Who is the agent? And does the agent have the authority to sign the admissions agreement at the skilled nursing facility? The Advanced Health Care Directive is a legal instrument and it controls. There's no expiration date, and as husband is deceased, secondary agent, the child, is the agent. The agent will need to show the Advanced Health Care Directive to the facility at the time of admission, and under that document, the agent has the authority to sign the admissions agreement of the facility to admit Jane. You can always reach out to Kenner, and it's linked here for more information on admissions agreement. And also note that by signing the admissions agreement, agent is not responsible for payment if Jane is unable to pay. In fact, it's illegal for a facility to require a third-party guarantor of payment as a condition of admission in a nursing home. Again, we have the legal code here. You can always reach out to Cantor for more information on third-party guarantees. But also keep in mind that nursing homes differs from assisted living facilities. They're two separate entities and they're treated differently under the law.
So, study number 2. So, Jane from the previous hypo needs to remain in skilled nursing facility long term because she needs 24/7 nursing care due to her advanced Alzheimer's. She has Medicare, but her Medicare coverage will end soon. She has Social Security retirement income of 2,100 and assets of 120,000. What are her options to remain in a long-term care facility? Next slide. So she does have options through Medi-Cal. She can apply through, or her POA. She has can apply for Medi-Cal, and Medi-Cal would pay for a majority. She would have a monthly obligation called a share of cost. Um, so her POA could apply online on her behalf, and there is a specific form called Appointment of Authorized Representative, MC382. And the link is provided that can be uploaded with the application. So we provided a link to the different fact sheets on this because there are many different issues that people have with including Medi-Cal eligibility, Medi-Cal asset reinstatement, which there is now assets that are there's a asset cap, and then there's also Medi-Cal recovery. And we have fact sheets for those. So for people that are planning on applying for Medi-Cal, these fact sheets are very helpful. And my suggestion is to review them before applying. Next slide. Oh, that's fine. So case study number 3, Jane now resides in a nursing home. Jane does not have capacity and her son is her agent. Son tells the staff not to allow Jane's daughter to visit Jane. Son and daughter do not get along. This happens a lot, especially when family members do not get along. Hey, Jane's son is agent limit who visits Jane in the nursing home. Next slide. No, there's actually a law that prohibits that prohibits a POA or anyone else limiting a resident's visitation right. She also still has the right to Jane still has the right to make a medical decision. As far as visitors, if the son feels that, the daughter is endangering Jane, he has to demonstrate it through court, through a temporary restraining order. And so he can't just, sometimes though, it's worth noting that the nursing home will go along with what the POA says. And so what Jane's daughter could do, or if anybody else that's limiting visitors for Jane, they can file a complaint with Department of Public Health, which is an enforcement agency of nursing homes. Next slide. Oh.
Sorry, go ahead.
Okay, durable POAs and advanced healthcare directives are documents that protect you while you're alive and at death, or end at death. So there are other estate planning documents that can protect you after death, and which is a will and a trust. A last will and testament tells the court how a person's assets could be distributed after they die. It doesn't have to go through probate, which is the court's process for validating a will and overseeing distribution. Though if an estate is under a certain threshold, which is currently under around 208,000, a more simplified process called a small estate affidavit may be available instead. Two things that you want to keep in mind about wills is that, firstly, assets that pass through a will are subject to Medi-Cal estate recovery. And this is basically where the state can seek reimbursement from the state for any Medi-Cal benefits that were paid. Second, the probate process is public. The will that gets filed with the probate court becomes public record, which means anyone can look it up what assets the person had and who received what. A revocable living trust is a document you create during your lifetime that holds your assets, things like your home, your bank account, and investments. You typically remain in control of everything while you're alive and have capacity. You're usually your own trustee. You can change it, add to it, or cancel it at any time. That's what revocable means in revocable living trust. The trustee is the person who manages the trust. This is similar to an agent under a POA. While you have capacity, the trust successor trustee, which is someone who steps in to manage the trust assets if you become incapacitated or when you pass away. Just like choosing an agent, you want to choose someone you trust as a successor trustee. If you become incapacitated, your successor trustee can step in and manage those assets without needing a court order. The main advantages to having a trust is that it avoids probate court and it also avoids estate recovery. And unlike a will, it stays private. Next slide.
So another tool alongside having a will, trust, or the other advanced planning documentation is beneficiary designation. A beneficiary is a legal arrangement that determines who will receive a person's assets when they die. So when you name someone as a beneficiary, you're saying they're going to receive something. In your will and trust, anyone you're leaving something to, they're a beneficiary. When you use it in the more common ways, such as with a bank account, a life insurance policy, or a retirement account like an IRA, 401k, etc., you're providing access directly to the list of beneficiaries to receive those assets from those sources immediately after your death. It avoids the probate process. It also exempts it from your will and trust. So if you have beneficiaries listed on your bank account, but in your will you say you want to go somewhere else, the bank does not care. They're going to go with what is on the beneficiary of the bank account. So you want to make sure that those are the same. Bank accounts also have a few different policies. There's a payable on death, which means when you pass away, that whatever's in that account is paid out to that beneficiary. There's some banks also offer a transfer on death. So that says that when you pass away, the ownership of the account transfers to the beneficiary. Another thing to keep in mind is the primary and the contingent beneficiaries. The primary is the first in line to receive the asset. So the first person you have listed, that's the person who's going to get it. But let's say something happens to them. They're incapacitated, they've passed away. Well, you have a contingent or second in line if the first person passes away. The common mistakes are leaving designations completely blank, not naming anybody. Another option is naming minors, and there are special laws controlling when minors can receive gifts from an estate. Another thing is not naming contingent beneficiaries in case something happens to the first one. Another one is forgetting to update beneficiary forms. And the last mistake, even though it's not listed here, is naming someone who has a disability or receives public benefit from receiving direct inheritance. So on this slide, we have a couple forms listed for you. There's the Advanced Health Care Directive, that's statutory, the statutory power of attorney, and the last will and testament is statutory. All three of those, the power of attorney and the last will and testament are from the Sacramento County Law Library. They have those forms for free. What's also linked is the supported decision-making agreement from the ACLU, which is a kind of simple, clear-cut way of, I'm making an agreement that this person is going to assist me with making decisions. Thank you for coming out to our presentation. It's been wonderful having you. Community Council's information is on the slide, as well as Canner's.
Wonderful. Thank you so much for sharing this information with us. I think this is going to help a lot of people. I know I got smarter just listening. So thank you again so very much. And again, please reach out to either of these organizations or here at Caregiver Resource Center, and we're all going to help you find whatever answers you're looking for. So thanks so much. Take care.